Hi, everyone. I'm Peter Giannetti of the International Housewares Association and Homepage News. And welcome to a special webinar, Decoding the New Jersey Recycled Content Law, presented by IHA as an educational service to its members. In today's presentation, Sal Anderton, Vice President and General Counsel for New Jersey-based Porzio Government Affairs, will provide key details of the New Jersey Post-Consumer Recycled, or PCR, content law. He'll include background on the legislation, manufacturers and products covered, PCR content requirements, compliance, exemptions and waivers, and penalties. Companies are going to have to determine whether their products or containers and bags are regulated under the law, and if so, they must register as a manufacturer of a regulated product per the terms and timeframes established in the law. We'll leave some time for questions at the conclusion of today's presentation. Please use the Q&A function at the bottom of the Zoom window to submit questions, and we'll get to as many as time allows. A video of this webinar and a copy of Sal's presentation will also be made available soon to IHA members. With that, I'm actually pleased to introduce Lisa Bromberg, a principal of the law firm of Porzio, Bromberg, and Newman. Lisa will open today's webinar with a few thoughts before turning it over to Sal. Lisa and Sal, welcome.
Thank you, Peter, and thanks for the opportunity to talk about the New Jersey Recycled Content Law. We're very honored to have the chance to talk to the International Housewares Association about decoding the New Jersey Recycled Content Law, what you need to know. As a lawyer, it's always gratifying to know how much New Jersey continues to generate confusion and chaos in all things environmental and perhaps otherwise. We pride ourselves on being in the forefront of the states with the most Superfund sites. We had a contest a few years back to come up with a new motto for the state. Somehow Garden State didn't seem quite right anymore. And my favorite contender was New Jersey. Hey, got a problem with that? And so once again, we have, as we have had so often in the past, a new law with no regulations, little guidance, no more than 3 people at Trenton running the program, and of course, serious penalties and far-reaching consequences, mostly unintended, which is why I'm sure so many of you are joining us today. Let me introduce you to Sal Anderton, who is our resident expert on this new law. I'm very proud to introduce Sal as our newest partner in the law firm. And as Peter said, Sal wears another hat as well as Vice President and General Counsel of Porzio Government Affairs, our lobbying arm, and one of the Porzio family of companies. In that capacity, Sal is our secret weapon and works closely with the legislators on pending and new laws, and has been in almost constant contact with Senator Smith, one of the original sponsors of this law. When Sal isn't doing that, he's working with the DEP on an almost daily basis, trying to figure out how to comply with the many different scenarios that this law appears to cover. Just a little bit of a spoiler alert. In the absence of guiding regulations, this law is difficult to understand, and worse yet, involves a serious amount of math and detailed record keeping. Our representation of clients in this area is taking us to some strange places, starting with lobbying on behalf of the International Bottled Water Association when the law was pending, and then to representing manufacturers of products ranging from the cardboard containers that your spring plants come in, to the plastic bag that lines your box of Dunkin' Donut coffee, to your laundry baskets. And so we thank you for your time and patience. And Sal, it's all yours.
Thanks, Lisa, and thanks, Peter, for having us. So, yes, folks, I'm happy to make this presentation to you, and we'll have some questions at the end. I'm going to run through it, but like Lisa said, there's really a great deal of complication, and every situation, every company is going to have a different set of facts. So we're obviously going to present the general applicability provisions, and we can always get deeper in questions as specific issues pop up. So first and foremost is what the intent of the law is. And I can tell you by all means, the law is intended to broadly regulate and ultimately reduce the amount of plastics by increasing the amount of recycled content in plastic wares throughout the state. There's a whole host of legal issues. We're not going to necessarily get into those. We're going to presume for now that the law is going to continue to be in force and in effect and unchallenged. There will come a time, I suspect, where this law will be challenged in court. But for our purposes, January 18th, 2022 is the effective date of this law. It was passed 2 years earlier, of course, not necessarily on anyone's radar screen, unless you had specific representation in Trenton and were aware of it otherwise. But as of January 18, 2022, certain companies, and we'll go through who's qualified and why, have to adhere to the law's requirements for PCR content. So what does this law do? It regulates certain containers and packaging products, paper, plastic carryout bags, plastic trash bags, glass containers, plastic beverage containers, and super broadly is the category of rigid plastic container. We'll get into why that is a super broad definition. The PCR requirements, we'll speak to them when we get to that section of the presentation, but suffice it to say for now that there's an increasing, the requirements are increasing every couple of years, depending on the product, in regards to the amount of recycled content that has to be included in your products as new to the marketplace. And the law initially prohibited the sale of packing peanuts. That has since been put on hold. So let's start with who is a manufacturer. So a person that produces or generates any of the covered products, which we talked about, is for sale in New Jersey, is a manufacturer. You might say, well, I don't know what products are going into New Jersey when they leave our factories or our warehouses. They could go to Pennsylvania, anywhere regionally or even national. So that's certainly an issue, and that's one that touches on some of the potential Commerce Clause issues that might be involved in this law. But again, we're going to just presume for now that we're moving forward with this and have to comply. So a person that generates or produces a covered product, a person that is the brand owner of a covered product.
You want to share the screen at this point with the folks?
It says that I am sharing.
I'm not seeing it.
Let me redo it and see if that works.
Okay, I think people can see it.
Oh, sorry about that, folks.
Okay.
So who is a manufacturer? So a person that produces or generates one of the covered products, a brand owner of a covered product, unless that brand owner identifies a licensee who agrees to accept responsibility. That has happened, and we've drafted some of these very simple agreements for companies who want to essentially offload the responsibility for compliance under this law. And then in the absence of either a clearly identifiable producer or generator or a brand owner, there's this catch-all phrase, who is a manufacturer? Anyone whom the state may exercise jurisdiction over, an importer or a distributor. Again, very broad prophylactic definitions. Chances are, if you're manufacturing any one of these covered products, you're going to be considered a manufacturer. Or if you're, if you have the market power and have other companies producing your products, you might be able to delegate to them or assign to them your responsibility under the law. That's entirely possible. The manufacturer, however, shall not include anyone at a single location, which probably doesn't necessarily include anyone on this presentation, but just be aware that there is a very nominal exemption. So what if I'm a manufacturer? So what if my company's a manufacturer? You'll have to register. Registration requires the submission of spreadsheet full of your products and explanation in various buckets of covered products. Some of you online might have already done this. If you haven't done so, you really should by now, if you're determining that you need to. There's again an exemption for manufacturers under 5 million in gross revenue. Manufacturers that only produce exempt products only need to register, but they don't need to file anything beyond that. And obviously, the failure Lisa had mentioned, some of the penalties being very bothersome. There's at least throughout the law, we'll see that there's at least a provision or a time period to cure, which is helpful, right? And all of that leads ultimately to registration in this kind of clunky spreadsheet. And while I think the technical kinks have been worked out, there were earlier some technical kinks in the state's portal. So what products are covered? So basically, if you're producing any of these products, you're going to be covered under this law. The products are covered. Glass containers. That's a container made of glass that is filled with food or beverage. Paper carryout bags, plastic beverage container. This is obviously what's making the beverage industry concerned about this law. Plastic carryout bags, plastic trash bags of a certain thickness, and designed and manufactured to hold, store, transport materials to be discarded, recycled, or composted. So again, knowing the crowd on this particular webinar, glass containers, maybe even plastic beverage containers, and probably to some degree plastic trash bags, especially, would be notable for this crowd. It's interesting, as the law was discussed and socialized in the news and publicly here in the New York, New Jersey media market, it was typically called the plastic bag ban. So of course, the devil's in the detail, right? So if you're just watching the news and you say, "Oh, it's a plastic bag ban," well, it's much more than just a plastic bag or a plastic carryout ban.
Sal, some people in our audience they may sell plastic food storage containers, glass food storage containers, plastic household storage containers or totes. Are those products going to be covered in this?
Yeah, they will be, Peter. We'll get maybe in another slide or two to some of the more granular definitions, and you'll see where those food storage containers and other similar containers are covered. But so for the short answer, yes, and we'll get into why in just a few moments. Well, we're just about there. Rigid plastic container. So a rigid plastic container, as defined in this law, means a container made of plastic that is relatively inflexible, has a minimum capacity of 8 fluid ounces or equivalent volume, and is capable of maintaining its shape while empty or while holding other products. So I think this is going to capture, Lisa had mentioned like a laundry basket. This is going to capture horticultural containers that typically hold plants or, things of that sort. Peter, this is going to your question, capture, the food storage containers that do not have product in them, that are sold merely or simply as rigid plastic containers. And of course, there's, very narrow capacity, parameters. But for the so maybe your biggest plastic containers that are plastic storage containers might exceed the 5 fluid gallons or equivalent volume. But for the most part, I think between 8 ounces and 5 gallons, you're going to have a very large array of products that are manufactured by people on this webinar. So the PCR content requirements under this law, you could see that for rigid plastic containers, for example, in 2024, you will have to demonstrate that at least 10% of the product is PCR content. And then in 3 years, that goes up another 10%. And 3 years thereafter, another 10%, et cetera. Same for beverage containers, same for glass containers. Same for plastic bags. 40% for plastic bags, depending on their size. And then for trash bags, again, depending on the thickness, these are their requirements. So basically, the requirements increase in 3-year increments. I could tell you that the 3-year increments are intended to provide industry with time to, adjust, make whatever arrangements. Again, a lot of this is going to depend on the market for available PCR. So there are absolutely intangibles that we don't know, market conditions that we just don't know yet. Will this ultimately increase the price of your products? In some instances, probably. Maybe I'm being optimistic. Some of you are probably in the back there saying, yeah, absolutely. There are exemptions to the law. So a rigid plastic container, again, that I think just being sort of one of the more common products, a rigid plastic container is exempt from the PCR content requirement if it is associated with a product destined for shipment outside the state and remains with that product upon shipment. So probably doesn't apply unless you're shipping from New Jersey, but it might. 2, if the container contains drugs, dietary supplements, or some other regulated product. Same thing in exemption number 3. Just regulated under a different set of laws and by a different federal entity. If the container is manufactured for use in the shipment of hazard materials and is subject to some other federal law or regulation. Here's an interesting one. A rigid plastic container is exempt from the requirements of this law if it is refillable or reusable. But that's not necessarily as simple as it sounds, right? So your typical, for example, plastic water bottle. You say to yourself, I take one water bottle and I fill it up 3 or 4 times during the course of the day. It's refillable and reusable. Well, not pursuant to the definition of this under this law. Similarly, you might say, well, using Peter's example from a few moments ago, well, the food storage container, whether it's glass or plastic, is reusable and refillable. I use it, I wash it, I use it again. Again, not under the definition of this law. So again, that's an exemption, but under this law, and I didn't get into the details of the definition of refillable or reusable here, but just be aware that it's a very specific definition. So for example, a container is only refillable if you bring it back in the course of business to the manufacturer. Think probably like your office water cooler, right? We all know that's refillable because the manufacturer or the distributor picks it up, washes it, refills it, returns it. There probably are some products that are maybe refillable that contain certain types of foods or spices. But again, that exemption, while it seems very clear, is not and is very narrow. Other exemptions include milk products, plant-based products that include dairy. So milk, basically, and other types of milk, soy, oat milk. Medical food or infant formulas, special dietary food. Trash bag is exempt if it is intended to hold or store hazardous waste or medical waste. And then probably applicable to some of you on this call would be that a plastic package or container containing food is temporarily exempt for 5 years. Again, that's probably one of the more useful exemptions that we might find here, but we can get into that a little bit more specifically later on in Q&A. So we talked about who's a manufacturer. We talked about what products are covered. We talked about exemptions. Now there are waivers. So exemptions are just that, exemptions. Those products that we just talked about that fall into those categories are exempt. However, manufacturers can also apply for waivers if one of these 4 reasons exists. If the manufacturer cannot achieve the PCR content requirements and remain compliant with a state or federal law. If it's simply not feasible technologically for the manufacturer to achieve the PCR content requirements, if the manufacturer cannot comply due to inadequate availability of recycled material or substantial disruption in the supply of the material. So those are the three categories of waiver that are currently available. This fourth one, which the law allows, is a manufacturer cannot comply, is eligible for a waiver if they cannot comply for another reason as determined by the department. But the department hasn't said anything yet. They haven't provided regulations yet. So number 4 is not yet an option available to someone who wants to seek a waiver. As Lisa had mentioned at the outset, the Department of Environmental Protection here was required to promulgate regulations by the effective date of the law, which goes back to January. So now we're basically 8+ months past that, and we don't have regulations yet, only further complicating our efforts to comply. But be aware that the department is accepting waiver applications if you can qualify under one of these three categories of waivers. We've submitted waiver applications on behalf of some clients, mixed success. Recognize that what's not in here, and I've had this conversation, and I'm sure some of you were thinking, well, if we provide PCR at certain levels, the products might become more fragile, it might not pass a drop test. It's unclear. Again, this is all new. So it's not clear if that is a reason for a waiver. In other words, your own corporate or brand quality standards might not be satisfactory as a reason for a waiver, because it's still technologically feasible, even though you might not be satisfied. So that's an example of a real gray area here. Similarly, if there's inadequate availability of recycled material, you're going to have to seek a waiver that's supported by affidavits or explanation certifications from suppliers. And your suppliers are going to have to say, we can't get enough PCR content to satisfy this particular product. So if you have, for example, a spreadsheet full of, let's say, 100 regulated products that you make, you may seek a waiver only for a few of them, right? Under, let's say, number 3 here, because you don't have enough PCR content, for example. So you're going to have to match up in your waiver request the product with the supplier's explanation or certification that there isn't sufficient or adequate material available. So complicated. The first one is a little less complicated and should be pretty straightforward if you simply can't comply because of a state or federal law.
Sal, excuse me. This may be because I missed the specific class in the law school that I didn't get accepted to, but there are details of the law that you're outlining, but then you say there are no regulations. Can you sort of reconcile what that really means when you say there's no regulations yet? What is the difference between the details, the law, what's specified in the law and regulations?
Yeah, so there's going to be, so you're right. There are going to be some gray areas that are not necessarily clear, and one would in the law, and one would expect regulations to sort of fill those holes, and so we don't have that yet. So that's still creating a challenge for compliance. Number 4 on the screen here is a perfect example where the law says that there's a category of waiver where a manufacturer may be eligible for a waiver if they can't comply for some other reason that the department determines is a valid reason, but the department hasn't promulgated any regulations setting forth such reasons. So that's just an in-your-face example. So that's, unfortunately, all this means is that there are still some areas where there's gray area or potholes, if you will, in trying to comply.
Thank you.
There is a possibility for alternative compliance plans to be entered into for certain of the products. Typically, as you see in the last paragraph, that might be most appropriate for like certain trade associations or groups of manufacturers who have sort of common issues with compliance. Probably not something that's necessarily apropos for this crowd, but again, the law does provide sort of a narrow window for alternative compliance if it's appropriate in a given industry. I'm not aware of anyone who's done that yet. So take a look real quickly at penalties and enforcement. So the commissioner of the state DEP has the authority to issue an order requiring compliance, issue a time frame, and give a allegedly non-compliant entity a right to a hearing. That's like, an administrative order. Number two, civil action, inclusive of costs of enforcement, going to court. Levied administrative penalty, significant violation per day, adds up very quickly. Civil penalties, $50,000 per violation per day. Corrective action plan could be an enforcement mechanism. And, this one, particularly painful, I think, is public notice for violators. So there, is built into the law this and again, when you see how legislation or laws are made, you see that this came about because certainly there are, some sophisticated, lobbying entities who supported this law that say, probably the best penalty is public shame. What company wants to be held known as, not being a environmentally friendly or compliant entity? So, pretty wide array of options that the department has in terms of enforcement. Knowing or recklessly false or misleading statements carry criminal and civil penalties. So someone, as we're going to talk about, someone from your entity, if you determine you have to register, someone from your entity is going to have to make the compliance statement to the state of New Jersey. And that would be, this would be a penalty for any knowing or recklessly false or misleading statement. Regulations, as we already covered, we don't have them yet. They're now at this point 8 months overdue. Compliance, as of July 18th of next year, which is the 1-year anniversary of the effective date of the law, and annually thereafter, each manufacturer has to certify that their covered products are in compliance with the PCR content requirements of the law, or are exempt or waived. So basically, if you think about it, the law was effective January 18 of 2024. So not until July 18 of 2025, a year and a half later, forgive me, I misspoke, it was a year and a half later. Not until a year and a half later do you, if you're a registered company, have to certify your compliance with the 2024 PCR requirements. You'll remember those requirements we showed on a screen, several slides back. So your 2024 compliance is not certified to until July 18 of 2025. And then annually thereafter, you're certifying in July retroactively for the previous calendar year. Certifications, as well as exemption proofs and waiver proofs submitted through the DEP electronic portal. Be prepared to calculate in pounds the amount of PCR material and total material used in your regulated products. This is Lisa's warning about math being involved. And there is math involved. You literally, the law literally states, and there's a FAQ that I'm sure some of you, if not all of you, have seen. that does this calculation and shows you the math that's necessary. But in sum, very simply, percent recycled content equals the sum of recycled materials over the total quantity of materials used. The law directs you, and the FAQs direct you to use New Jersey specific data. Now, chances are you might not have New Jersey specific data, right? Especially if you're a national or regional supplier. You could use national average and then prorate it per market share or population. The law seems to give some discretion there in terms of what you're actually reporting, right? If you could make an argument for at least certain regional or New Jersey specific marketplace, you could probably use that data. It might be better. But again, everybody's math is going to be different depending on your logistics, depending on your supply chain, and the type of products. Maybe some products work very well with PCR, maybe others don't. So it all just really depends, and you're going to have to do your math. And then the averages may be calculated based on an entire product line or sublines, as long as all products are accounted for, obviously not including exempt or waived products. So again, think back to your registration, and you might have 50, 100 or more products covered. You could break them up by product line. Maybe you have several lines of glass jars. Maybe you have, rigid plastic containers. Maybe you have plastic bags. So these different lines can be factored or mathematically determined individually.
I'm going to interrupt you just because I have a question on this specifically, Sal, that's probably best to
Sure.
address now. Is in the penalties section, what is meant by quote unquote per violation? And let me add to that, if someone has a product that's offered in different sizes or different colors or slightly different configurations, that represents a unique stock keeping unit. Does each one of those SKUs have to be certified, or can, as you said, can the line that encompasses multiple sizes and or shapes or whatever, different colors, can they be grouped together?
So I'll answer your second question first, Peter, if that's okay. I've seen clients without objection from the DEP do it either way. They've done it as broadly as the 6 categories of covered product. As a product, your rigid plastic containers, one product line. Glass container, different product line. I've seen other clients submit based on much more specific, like if they had thousands of products, they've broken it out by product line, largely, but not necessarily around SKU numbers. So that might be, for internal housekeeping purposes, that might be the easiest way to do it, right? So that's okay. But I've also seen the DEP accept more broad categories of product line, so to speak.
And the per violation?
And the per violation, hard to say because nobody's enforced this yet, right? As you saw from the compliance slide a few moments ago, compliance really doesn't even kick in until July of next year. So I don't know, but I could tell you that this is intended to be very broad, and it is intended to be steep penalty. So per violation is probably going to be, if I were, the DEP and I wanted to really hammer someone, I would, consider each violation either a product line violation or perhaps even, most painfully, products in the field. So if you have products at one store, perhaps that's, multiple stores, maybe each store is a violation. I don't know yet because this it has not been utilized, but I do know it's intended to be broad and, sharp.
Very good.
So we are up to, the second half of our compliance slide. Again, show your math. There are significant penalties, as we noted before. There are FAQs, which may, in some instances, be helpful. I've had some good success communicating with the DEP. I've urged companies to go ahead and communicate with the DEP. You could do so specifically. Some felt nervous specifically, so they asked me, or they just emailed anonymously with hypotheticals. We're doing this. What if we do it this way? The DEP has slowed in its response time from a week to 10 days to a couple weeks now, based on my experience, because they are getting busier. But I do think, and I do know that they have, sort of taken account of some companies that have registered who are trying to do the right thing. I do think that's helpful. I do think it's better to be on record as trying to be compliant than not. I think it'll all come back to be a positive. Should there be issues in the future? Hopefully there aren't. So what are our takeaways here? Compliance period started in January 2024. Obviously, we're past that. You're saying to yourself, well, gee whiz, I haven't even registered yet. You probably should have registered by now. The DEP has publicly and privately said to me, listen, this law had a 2-year implementation period. It was passed, it was signed by the governor in 2020 and didn't go into effect into 2022. I sat there and basically respond like, well, this is what you do every day, but not everybody's paying attention to what you do every day. Having said that, you should if you think you have to register and you haven't done so, you should promptly. Yes, there are no regulations, as we've discussed. The DEP is communicating with regulated entities, albeit a slower turnaround time than it was several months ago. Registering and uploading your product lines may take you some time. You should speak to your suppliers, right, to make sure they can get the PCR content. Speak to your tech people, your labs, to make sure that your products can handle that PCR. You'd have some time to make adjustments if possible. Speak to your customers if you're supplying products to others. Consult your legal department, because there are significant penalties here, not the worst of which probably is shame, public shame. And then again, I want to reiterate, like, every situation is unique, meaning every company has different products, different amounts of product, different suppliers, different logistics. So all of that could factor in to how you could or might struggle with complying with this law. So every situation really is unique. There's no one size fits all. Peter will circulate this to you all after the presentation, but the law is here. The DEP's landing page, which has the FAQs, as well as access to the portal, is here. And then my phone number and email is here in the event that there's a need to do some follow-up. So Peter, I think we've reached the end of the presentation, and I'm happy to take some questions if there are any.
Thank you so much, Sal. Yeah, there are some questions. And just a reminder, as Sal said, we will be sharing this presentation to today's attendees, as well as the a video of this session. So that'll come soon. I just want to start, for those who joined us late, there was a question, but I think it's a good place to start this Q&A. Just for clarification, if you're a manufacturer outside the state of New Jersey and you sell to customers in New Jersey, then you must comply with the New Jersey state law, correct? So anybody, if you're selling a mass retailer in Arkansas, for instance, that has stores in New Jersey, you've got to comply.
That's right.
That leads me to a question: is where is the liability across the supply chain here? Some of the people on our listening today might be primary manufacturers. They may be purchasing product from a source, and there may be lots of stops for that product from origin to the retail shelf. Is the retailer also part of in the line of fire, if you will?
Yeah, so you'll remember one of the early slides were the definitions of who's the manufacturer. And if the manufacturer is, so there is ultimately a manufacturer. Remember, we talked about there is the possibility for one company to assign its rights or its obligations under the law to another. I could tell you that some of the large national chains have done that, where they've assigned their obligations as manufacturer to their suppliers, right? So there's an imbalance of market power in that type of situation. What are you going to do? Like tick off a big customer and say, no, we're not taking responsibility for that. So the short answer is you got to look at the definition of manufacturer. There are some entities that might fall through the cracks there, but ultimately it's, even at worst, or I should say at minimum, it's going to be the importer of the product, Peter. So there will be some entity responsible for that product being distributed within New Jersey.
Gotcha. A couple other questions. One is the $5 million exception that you spoke about. The question is this referring to total sales of the company or of the items that are regulated?
Total sales of the company.
Okay.
So it's essentially a small business exemption.
Right, right. On the issue of the law applying to packaging, is it, the example is a plastic bag that is used inside the retail packaging to hold components. Is that covered under the law?
That's interesting. So I think that it's not going to be, that's not going to be covered under the definition of plastic bag.
Okay.
No. I would only caution, like take a good look at the definition of plastic. Oh, wouldn't be a container either, would it? Because it's a bag. So that might be an example of a product that doesn't have a clear bucket to fall in.
And that could come with the regulations as they, whatever.
It might.
Yeah.
It might. I would say that, again, just based on your quick description, it's not a plastic container and it's not a plastic bag based on the definition of a plastic bag. So you might fall between a crack there with that particular product.
And I think there's that gray area,
that's a gray area,
foggy mist that's hanging over this is an example of that. And to our listeners and attendees today, you have some contact information that'll be coming away. If there's any follow-up that we don't get to today, obviously we encourage you to connect with Sal and his team.
And similarly, if you have a question, you could even do an anonymous email to the department, right? And that might be a good question. I've had clients send pictures to the department attached to their emails just to say, what about this?
Thanks. Is there a reasonable possibility that the scope of this law will be narrowed away from durable consumer products, which fall under the definition of rigid plastic containers, and focused instead only on the non-durable containers?
That's a big part of our lobbying effort recently, right? So you would think, for example, that a rigid plastic container that we use, let's say, as a laundry basket, right, is a good thing. Like, how many laundry baskets do you really buy in your lifetime? I don't think any of us are arguing that, the landfills are filled with Peter's old laundry baskets, right? It's probably not the bad guy product, but I could tell you that the advocates and the sponsor of this law intends for those products to be covered. So I wouldn't rule it out yet. And I agree with the intent or the spirit of that question. But as of right now, that's still the law. And I'd say 50-50 that changes. I will tell you, and I should get to it, that there is an effort afoot in New Jersey to enact an EPR, extended producer responsibility law, similar to a handful of other states that have done similar EPR laws. Colorado, Minnesota, and a few others immediately jump to mind. So there's going to be another bite at the apple in terms of what does New Jersey's plastic regulatory landscape look like. So I don't want to rule it out, but I'm a little skeptical because I really do think that that's the type of product that is intended to be covered by this law.
You mentioned different states. With regard to the PCR content, are there any other are there any other states close to this right now? What's the national landscape look like? And does the first state that sets these laws sort of set the template in place that other states will follow?
You know, I don't think New Jersey was the first, but I think it might be the broadest in some respects because of that, what constitutes a rigid plastic container. I will also tell you that Canada, on a federal level, has had PCR laws in effect certainly prior to New Jersey. I'm not sure if it was prior to any other state law like California's, but companies that sell into Canada may have a leg up in terms of compliance here, or maybe they use different factories and could speak to that more specifically. But no, I don't think New Jersey was necessarily breaking any records with this law, except as to the breadth of it. That I think is broader than we've seen in other.
And again, if New Jersey has widened or added breadth to broaden the scope, does that sort of does that ultimately become a template that you think other states who are exploring this tend to lean into?
It could be, right?
Yeah.
It could be. And then again, the caveat, and again, I don't have a crystal ball, but with the caveat that as states enact EPR laws, maybe that changes, right? Because so much of the content is going to be fungible, right? If you have EPR requirements, maybe you don't need such strict PCR content requirements. So
right.
I think this is a hot topic in states now. Once it mellows out or lands, you might get some more clarity, Peter, to the type of questions you're asking. I'm not sure it's there yet. So even in our state, we have a whole host, truth in recycling. There's a bottle deposit law. Like there's so much being thrown against the wall right now in terms of regulating containers and bottles and glass and plastic. You just don't know what's going to stick. Now, of course, we have a very long, drawn out 2-year legislative cycle. Some states that are shorter, they're going to act more quickly. New Jersey just doesn't act very quickly, typically.
Sal, in response to the question about whether or not it seems likely that the law will become less inclusive, do you think that lobbying efforts like those that would be put on by big product associations would help? Or do you think that's right?
I could tell you, having spoken with the regulator and with the prime sponsor of the law, like, as people like me are saying to these folks, this is tough to comply with for a host of reasons. They're not so necessarily impressed, Lisa, that it's broad. It's supposed to be broad. Plastic's plastic, right? But they are impressed by the difficulty in complying, right? Because what good is a law if no one can comply with it, or if it's very difficult to comply with? So I would urge any companies that are tweaked by this law, to at least chime in and say, hey, this is really difficult to comply with. We don't know how to comply with it given our circumstances. And whether that's in the form of a communication to the DEP or to the bill sponsor, whatever it might be. But yes, I mean, I think every 2 cents helps here, to be honest with you. I don't say that to be trite. I just think it's helpful.
When we talked earlier this week to get ready for today, I knew that a lot of questions we were going to get is someone looking for very specific clarity on whether their product might or might not be covered. So I'm going to give you a couple of questions that are in there right now. One is going back to the laundry basket example. Is there a way to explain why a durable, reusable laundry basket is subject to this? Is there something endemic to a laundry basket that makes it that covers it under this law?
I'm just a messenger, but because if it's made of plastic and it fits into that definition of a rigid plastic container, remember it had like the 8 ounce to 5 gallon capacity limits. If it fits into that definition, it's covered by this law. I'm not making a policy statement. I'm just saying that that's what it is. So that's why, and it's a ridiculous example because it goes to show how broad the scope of this law is. I've similarly I've used to find like a preposterous example. The fork, spoon, your utensil tray that's in the drawer next to your stove, right? Everyone's got one of those. Some people have a metal utensil tray. Some people have a plastic utensil tray. In that instance, is a rigid plastic container. So
Interesting.
this law literally goes into your kitchen drawer.
Yet to be clear, a plastic kitchen utensil, kitchen gadget, that's not going to be covered under this law.
Not a container unless it's a container.
Right.
So if your idea of a gadget is a measuring cup,
that would be part of that wall of gadgets. Yes.
So you see how broad and how really difficult this law becomes.
Right. Right. Back to the packaging. I know you touched on this a little bit with the question about the components that are inside the box. Someone's asking, with regard to housewares products, let's just use a piece of cookware specifically. How does where does the packaging kind of enter the equation? Is it wrapped? Does it have to be wrapped by plastic? If it's in a box and it's wrapped, the product is wrapped, the actual product itself comes in some form of bag, is that going to be covered?
Yeah, the package container will be. And again, it's going to depend. Now, it depends what's in there. So in your example, so we know food, we addressed food in the presentation. But if your example is like, a crock pot, for example, let's say, a box, the question, I guess, is the packaging in the crock pot, the styrofoam and whatever else. So you do have some styrofoam covered by this law, which the DEP has relented on temporarily. So you want to check that. Again, I'm not a scientist, so you want to make sure that their exemption is specific, fits your product, because I know that there are different types of packaging products that are essentially styrofoam. The cardboard box is a different question, right? So if a product comes in a cardboard box, different question. And then again, I don't even know, because I haven't addressed yet, but I haven't really thought about whether or not Amazon or any of the FedEx or any of the logistics suppliers, to your point before, Peter, are they caught up in this liability chain? I don't know if it'd be a great question if any of your members have seen that come up yet. I don't think that the law intends to capture the logistics providers in terms of responsibility. Maybe they are providing some of the containers. But the containers themselves will be covered here. So yes.
If that wraps up the questions we have in the queue, I have one more question, but there's a couple minutes left if anybody else wants to drop in a question in the Q&A. It's the issue of enforcement. Again, you need regulations, I guess, to have enforcement, but do you expect there to be a real boots on the ground movement, an enforcement mechanism? What can this industry expect when it comes time for enforcement?
Yeah, I do. This again, incredibly broad law. So the state's resources to enforce are going to be limited, because, like, gee whiz, who's going to go into every retail establishment in the state, right? But that public shame penalty is important, and the registration is public information. So if you're a name brand, and there are going to be advocates out there, environmental advocates who are going to be keeping an eye on this.
So there'll be more blowing than direct government enforcement, if you will.
I suspect so.
Yeah.
Again, how many full-time employees can the state of New Jersey have out there, right, looking at products? But for sure, if you're a name brand, a national brand, and people know your products are out there, that's going to be easy to find.
Right.
So I do have to caution folks about that.
Sal, is there any kind of closing remark before we wrap up today? Anything, kind of one thing to leave them with? I know you went through a lot of the takeaways, but what's on top of the list?
Yeah, I think just the breadth of this and the complexity of it and the penalties and public shame make it a real threat. So if you have not yet really considered how or whether you have to comply, do so quickly, because it is, you don't want to be the first one out there that's not complying.
Gotcha. One quick follow-up on the earlier reference to the crock pot packaging. The question is, are you saying, in the example, are you saying that that the pot is shipped in a color box, 4-color box, and the pot is in a poly bag inside that colored box? The poly bag is within the scope, or could be within the scope, as could that box.
Yeah, so the plastic bag, again, I'm going to go back to the definition of plastic bag. So the plastic bag probably would be covered there because it's intended to transport a product, right? The, the cardboard box, not a plastic container, not a carry-out bag. So you might be off the hook in terms of a regulated cardboard box, I'm sorry. The plastic bag is going to be covered, I believe, because it's a plastic bag intended to carry a product.
Well, I want to thank Sal Anderton and Lisa Bromberg from Porzio today for helping get the conversation started. And hopefully we helped you become a little bit more aware of what you're going to be facing, even though it's very clear that it's not very clear about where this thing is headed right now. I think the message here is, if you think you might be covered, you don't sit on that. Try to find out. And again, you can connect with Sal and Lisa on that. I want to thank them for sharing their insights. The IHA is committed to bringing our members as much up-to-date information on regulatory and legislative issues that are affecting this industry. And as we all know, there are so many more of them, and it's tough to keep them balanced. Just a reminder, we will be updating industry executives on this and other regulatory and legislative issues at the upcoming Chief Housewares Executive Super Session. As you know, at Chess, that's September 24 through 25 in Rosemont, Illinois, and that's open to IHA member senior decision makers. You can go to housewares.org to get more information on the Chess conference and to register attend. Again, thanks to Sal and Lisa. We will hear from you again, I'm sure, and we do appreciate your time. On behalf of the International Housewares Association and Homepage News, I'm Peter Gianetti. Thanks for joining us today, and we will see you next time. Thanks, everyone.
Thank you.